Morning, everybody. Let's get started so we can get going on time. We've got a lot to cover today. I'm Tim Ahrens. I'm chair of the Benefits and Compensation Practice Group here at Dorsey, and we're pleased to present today our annual forum on employer retirement plans. A little update on what's going on in our world. A couple of announcements. We've got a number of people on webinar as well. And we've got some sign-in sheets for continuing education on your table. Note that you're going to need to do a separate sign-in sheet for the second session as well for the CLE credit. So we'll be picking those up in between and then putting new ones down. So if you want both hours of credit, you'll need to sign both of them. A couple of other things. A few people in our group that are kind of out and about that you may or may not know, but maybe you've talked to on the phone. We've got Tim Goodman in the back, a partner in our group. He'll be up here later this morning with me. Karn Kopa, raise your hand, Karn. Some of you have, I'm sure, interacted with Karn. We also have Marianne O'Bara, who won't be here today. She's in our Seattle office. Melinda Mayer, I don't see Melinda down here yet, and Mike Vovis. And I don't see Mike down here yet. So I guess with that, Tim, did I miss anything? All right, let's roll. First, we've got on deck Liz Deckman and Andy Holly to talk about fiduciary management.
Thanks, Tim. Hi, I think first off, maybe Andy and I will just introduce ourselves. I think I've seen many of you before. I've been here in the Minneapolis office. I'm from Seattle. Liz Deckman, I'm a partner and do work in both the health and welfare space and obviously the retirement plan space. And I'm very happy to be here, although it is freezing cold. I'm not quite used to that.
Hi, I'm Andrew Hawley. I am a partner in the trial group where I primarily practice in the area of ERISA litigation with a little bit of tax litigation, but about 70–80% of what I do is ERISA litigation. And I guess we're here to talk about retirement plan committee best practices. And I think we both bring a somewhat of a unique perspective. I think that one of the things that we want to talk about here is our goal here is not just to talk so much about how to structure a plan to get out of a motion to dismiss or early on, but just best practices in managing your retirement plan committees, both with an eye towards fulfilling your fiduciary obligations, but also as a defense to litigation, as the two really overlap quite a bit. And I think that that's really what we're here to talk about.
Sure. So before we get started, I know we have a large group of attendees via telephone and webinar, so thank you very much for attending. But you're not going to be able to raise your hands at this question. I'm just kind of interested to see who we have here in our physical audience. Do we have a lot of plan sponsors? If you could raise your hand. Oh, good. Great. Investment consultants? Okay. How about other attorneys? Okay. And then sort of consultants in terms of 401k plan advising and consulting. Okay, a very good mix just for people who are on the phone. Is there anybody I missed? Okay, great. So, oh yes. Andy reminded me, we'd like this to be as interactive as possible. I think that makes it a much more lively discussion, and there's a lot to discuss in this particular topic. So if you have a question or comment, please don't hesitate to raise your hand. We will repeat the question so that people on the phone can hear us, and let's go. All right, just a first overview. We're going to be having sort of an ERISA primer on what is an ERISA fiduciary, what are your ERISA fiduciary duties in general, and then we'll get into sort of the meat of the presentation, which is sort of what are the general best practices, and then we'll turn to kind of ERISA plan governance and how we might take those kinds of concepts and apply them to different types of settings. And then lastly, we'll be talking a little bit about audits, litigation, and claims for benefits, some things to think about in the event that you have any of those. Well, for me, it would be an unfortunate event to have any of those things happen. So, Okay, so let's talk first off about who is an ERISA fiduciary. I think most of us know that plan trustees and plan administrative committees, maybe investment managers, that those types of entities are considered ERISA fiduciaries. Those are pretty clear. But I think that you should also be realize that there are also sort of functional fiduciaries. And ERISA has a pretty detailed description of who a fiduciary is. Is anyone who exercises discretionary control or authority over plan assets or plan management. If you have discretionary authority or responsibility for plan administration, or if you provide investment advice for a plan for compensation, or you have a duty or authority to do so. So even if you may not be called the plan administrator, if you are doing these things, it may be that you are a functional fiduciary and therefore should be aware of what the requirements are under ERISA.
And one of the themes that we'll be talking about throughout this day is how to make sure that you structure your plan in a certain way, your governance, I should say, in a certain way, but you also make sure that over time you don't see a kind of drift. Because this is, as litigators, this is what we see all the time. In year one, people are very careful to set up their fiduciary structure. This person's responsible for this person's responsible for that, this committee does this. And over time, retirements happen, or maybe somebody's really busy, or whatever happens, and suddenly you get into a situation where somebody who you don't want in sort of the fiduciary line of fire starts doing something, starts taking on a task. Maybe you don't want your board of directors to be in any way, shape, or form involved as a fiduciary, just because for litigation reasons, or for insurance reasons, or for whatever it is. But then at some point, something happens, or maybe an issue comes up, and they start dealing with it, and suddenly they're an ERISA fiduciary. And again, so that just the fact that you can become a fiduciary through your acts is something that people really need to think about and make sure that when you set up your structure, you are mindful of keeping to that structure, and mindful that you're at least being intentional about it. Because otherwise, suddenly you have situations where you have somebody you don't want being a fiduciary acting as a fiduciary, and that can cause not only problems in just generally, but can cause real problems in litigation. If, for example, that person under the plan doesn't have the authority to do something, well, suddenly the courts are asking why aren't they, and are they entitled to discretion, these sorts of things.
Okay, so let's go through the 4 specified ERISA fiduciary duties, and you probably have heard these often. The first is the duty of loyalty, or the exclusive purpose rule. In other words, you as a fiduciary need to act in the for the exclusive benefit of plan participants. Plan assets are supposed to be used to pay for plan benefits, except to the extent that you can pay for reasonable administrative expenses. So everything you do is supposed to be in furtherance of for the benefit of plan participants. Now, I think that sometimes you can have one person who is, as we say here, wearing 2 hats. You may have somebody who is, let's say, on the board of directors, is on the administrative committee for the plan, is actually helping administer the plan, but then is also making what we call settler decisions or plan sponsor decisions. For example, what the terms of the plan will be. That is not a fiduciary decision. That is a plan sponsor or settler decision. And so you have to know what hat you're wearing when you're making those kinds of decisions.
And this can get very, very, this is probably in many ways the trickiest part about ERISA, and it can get very, very complicated, at least particularly when if you work for a company, or if you're a service provider, where if you're a corporate entity, for example, that has mutual funds that invest in the plan, your own mutual funds that invest in the plan, or use your own record keeping services, or if you're a service provider who is providing investment management advice, but also is trying to sell the plan certain products or services or things like this. It can be very, very tricky, because you have to be On the one hand, obviously, there's certain parts of ERISA that allow for the use of affiliated funds, for example, or if you work for a service provider, naturally you're going to make money off the relationship in some way, shape, or form. But at the same time, you have fiduciary duties to the plan, and it can be very complicated to make sure that that you're acting properly when you're wearing your particular hat. And we'll talk about this throughout, but it's extremely important to manage that relationship, to document that relationship, and to make it clear when you're acting in which capacity, so that you don't see blurred lines where a plaintiff's lawyer can come in or the DOL can come in and suggest that, well, you are really, when you're exercising your plan fiduciary duties, you're really looking out for your best interest or your corporation's best interest, which can very quickly lead to a lot of problems.
Okay. Heading on to the second fiduciary duty, which is the duty of prudence. And this one I find also very interesting, because what ERISA really requires is that you have a good process. You don't have to have perfect results. You don't have to have selected the fund that has the best investment return for the whole year. You have to go through a process and find a good investment option, for example. But an empty head with a clean heart is not enough. So really, you're supposed to be acting with the care, skill, prudence, and diligence that a prudent man, I would say person, acting in a like capacity and familiar with such matters would use, sort of like a prudent expert. And so really, oftentimes what people are doing, what plan sponsors, plan administrators are doing, is they are hiring experts to help them out, to make sure that they are following this process and coming to a reasonable conclusion. But the problem is that you can't just rely on experts blindly. If you're going to choose an expert, you have to go through a process of trying to select that expert prudently, and then you need to monitor them and think about what it is exactly that they're telling you, and question what advice they're giving you. Don't just accept whatever they say at face value.
And this is, if there's the most important probably takeaway from this entire thing will be about the prudence standard and about the documentation and about what it means to be prudent. Most of you probably will not face loyalty, issues about loyalty, just because for most people, I think your plans aren't, that just won't probably arise in the most instances. But prudence is something that everybody will face. And what I can say is that as a litigator, what you like to see more than anything in the world is you'd like to see good documentation of prudence. And that doesn't mean, and we'll talk about this more, but that doesn't mean that there are no problems that come up, that everything is always smooth sailing and blue skies. That means oftentimes, and this is very counterintuitive for all of us, that means, and particularly those who've dealt with litigation, that means when issues come up, you directly deal with them, you document them, and you make choices. And I can tell you that as long as that happens, as long as choices are made, they are reasonable choices, they courts will affirm them. Particularly, oftentimes we're faced with situations where you have only bad options, and you choose one of your bad options. It's counterintuitive to us, particularly as lawyers, that because we never want to admit to problems or issues, but in fiduciary land, that's actually a very, very helpful thing. I'll just tell you one story about a case we had many, many years ago having to do with an investment, a plan's investment in a particular fund. The fund, it was a bit of a problem because the fund was affiliated with the sponsor, and the fund was performing very, very poorly for many, many, many years. But what the fiduciary did is they very carefully, and there was a big question of, do we keep this fund? And obviously it didn't look great because the fiduciary, the sponsor was making money off the fund, at least at some level, right? Well, what they did is they very carefully monitored the fund. The pension plan did, the 401k plan did. Every meeting, the investment advisor gave, the independent investment advisor gave updates about the fund, and they explained why despite the significant long-term poor performance of the fund, there were reasons to believe that that the fund was actually a very good one, that it was simply out of favor due to the particular market situation, and they stuck with it. And we never had to bring that issue to trial, but had we done so, we felt very, very good that we had a long history of people being intelligent, being thoughtful, and being deliberative about it, and we had a good story to tell. And we feel confident, and we always felt very comfortable that if we had to tell that story, we'd be successful. And I think that that's, again, one of the themes we have here today is proper prudence, but also documentation of your prudence, so that as litigators we can go back, to something that happened 5 or 6, 10 years ago sometimes, and say this is what they thought, this is what they were doing, this is how they deliberated about it. And if you can tell that story to a judge about people being honest and thoughtful about the plan, that's a winning story. That's a winning way. Yes.
And investments. So I think a lot of us kind of know about documenting process with respect to investment funds. What does that look like outside of investments when you're talking about other fiduciary duties like claims decisions and things? What do you see?
So the question was, what does documentation look like outside? What does prudence and documentation generally look like outside the context of just investments? I got that right? Yeah. And we will definitely talk about this later, but we can segue. That's a great question. It's the same principles apply, right? What you're trying to do is you're trying to document what's happened, and so that assume that in the best case and worst case scenario, assume 10 years later you are dealing with this situation. Litigators are coming in, there's a lawsuit, and you're trying to document what happened. And let's assume all the witnesses are gone or don't remember what's going to happen. Give me a stack of papers, and am I going to be able to figure out what people were thinking, what people were acting, and what was going on? And that's as a general principle. That's, I think, the way to think about it. And I will say, and you mentioned claims for benefits, and I think this is extremely important point. To the extent you have a claims for benefit, particularly significant one that might result in litigation, but all of them certainly, all of those things are going to be limited to an administrative record, but to the information that was put before a fiduciary. And when you have, as a litigator, when you have a nice set of documents, a nice, clean description of what happened, it's very, and this is a general principle, but I'll talk about claim for benefits right now. It's very easy to go to a court and to say, this is what they were thinking, this is the evidence they relied upon, and this is why they made their decision. And that's an easy story to tell, as I say. The difficulty becomes when somebody says, oh yeah, somebody told me something and I don't remember what they said exactly, but I didn't really document it, but I remember it happening, or this was a really key consideration, but we didn't really write it down in the decision. That's when you run into trouble, because that's not what ERISA is supposed to be about, and that's not what good fiduciary process should be about. Again, everybody's living their lives, and nothing's perfect, but you really are trying to sufficiently document your decision or the actions you're taking with not only the reason for your decision, but the evidence you relied upon. And I think the same thing could go, for example, with respect to a fee, a review of a service provider's fees, right? If every several years you're looking at your service provider, is it a good idea to keep them? Well, take a look and put in writing, who else did you call? We talked to 3 other service providers. We got bids from them. They told us that their bids were X and Y and Z, and here's the services they provided. And in the best of all worlds, you'd love to see some kind of PowerPoint that's given to the committee so they can see, here's the 4 service providers where I have, here's their fees, here's the services they provide. Is there benchmarking? That does your investment advisor able to give you benchmarks about their fees and compared to everything else? So it's difficult we could get into the particulars quite a bit, but I think what you're trying to do is you're trying to make sure that you've documented what you did and why you did it, such that in a perfect world, 5 or 6 years later, somebody who has no idea what's going on, with no witnesses to tell them what's going on, can make sense of why you made your decision, what influenced you. Does that answer your question?
Just one other comment to make on that is that oftentimes those decisions are made, for example, in a committee meeting, an administrative or an investment committee meeting, and taking notes, having somebody who's sort of familiar with the ERISA fiduciary requirements, taking notes, taking minutes, and writing down shortly after the meeting what happened and sort of the reasons for the decisions that were made. I think that is, I'm not a litigator, but riffing off of what Andy would be saying is that contemporaneous note-taking by somebody who knows sort of what the point is for these minutes, and making sure that you put that in writing and have a way to have it be circulated to the committee members so that everybody approves the minutes, and then you have the record. Keep whatever PowerPoints, whatever other documentation that was used to make that decision together. And, I know from my personal experience, I have clients where the benefits people are like, no, we need to have these documents for a certain period of time, and knowing like how long you should be keeping documents, because sometimes it ends up as a fight between the people who are in benefits worried about these kinds of claims versus somebody who's like, okay, we have storage issues, we need space. What can we do to kind of make sure that we fit within whatever timeframes that the company as a whole has versus what the benefits people would be needing them for.
You have a question, yes?
I know there are debates about how detailed the minutes should be. Should we say so-and-so asked this question, so-and-so answered this way? Who made the notion, who...
That's the question was, the level of detail that should be in committee minutes, and that's exactly the point I was going to raise next. There's no magic answer to it. Certainly, there's no right answer to it. But the right answer is that you should. At least I'm a big believer that in fairly detailed minutes, particularly if you're dealing with a controversial, complex issue where you have. When it's a big deal, right? Obviously, again, nothing's perfect, but. I've seen minutes where you have just a discussion was had about this issue and this was the decision. And I'm not a big fan of that because, again, if I'm coming in and I'm trying to defend the decision, I want to show the court that there was a robust discussion of the issues. And going back to the earlier point, it's counterintuitive for a lot of us, but if there's a downside, if there's a downside to the decision, or if there's a problem, I like to see that mentioned and to say that, the person X said this is a problem and this is a problem with our decision and it could lead to this problem. And that was considered, but the reason we weren't worried about that was because although this was a risk, this was the benefit, right? I personally prefer that. I personally prefer to see kind of robust minutes that kind of explain what happened because, again, that's what the whole thing is about, is good fiduciary process. Now, like all things, there's a danger to all things, right? And the risk is that the biggest risk with those is that you're going to inaccurately describe something. And if you inaccurately describe something, and then courts, or if sometimes people get sloppy, or what they will say doesn't reflect something in the PowerPoint, or so that can become a problem, to be sure. And I guess it's always a balancing act where there's no perfect answer to it other than to be careful and to make sure that your committee members are reviewing it carefully. But some people will say otherwise, but I'm a firm believer in detailed, robust minutes, that particularly in issues where it's going to be controversial, where there might be problems. So that would be my vote. Again, there's different approaches, but that's the way I look at it.
Okay, so the last two ERISA fiduciary duties, the first is diversification of plan assets so that you avoid large losses. We will talk a little bit about ERISA Section 404C a bit later, but to the extent that you can use ERISA Section 404C when you're creating your investment lineup for your 401k plans or your profit sharing plans, that would be a great thing to do. And then follow your plan terms, unless, of course, they're contrary to ERISA. Hopefully they would not be. But again, following your plan terms also, it makes sense to do that because that's what participants have been promised based on the plan document. But then you can also say, hey, the plan said to do this, we did this. It goes back to the process being prudent.
And that, again, goes back to the theme that I talked about earlier, is to make sure that not just follow your plan terms, but that also goes for like your investment, your other decisions, your charters, your investment plans, all your documentation. Make sure you're following it or updating it. One of the biggest issues is you'll have an investment policy. We find in litigation oftentimes is you'll enact an investment policy statement in year one. It will say all these wonderful things you're going to do. And, 3 or 4 years later, there's some prohibition on doing something that you're not following anymore. And maybe there's very, very good reasons for it. And maybe it makes perfect sense, but there's no documentation about it. And the plan and the investment policy statement was never updated to address that. And it's a very natural thing to kind of, put your investment policy statement together, for example, and then put it somewhere and kind of forget about it. And maybe something somewhere down the line, you have a a fund that wouldn't be appropriate under there or should be on a watch list or something, and for some reason doesn't get on there. And there might be very good reasons why not, but again, if ERISA is all about prudence and about process. And so having to explain that to a court why you didn't do it, particularly if there's not good documentation about that, is a tricky thing. It's one of the biggest issues we're always dealing with, is because one minor sort of paperwork snafu can be something that can be very challenging to explain to a court when they want to be able to see a nice, clean process where people are it's not saying that can't be dealt with, but it's always a problem, and it's always a problem we see where charters are created, policy statements are made, and then it's difficult to keep them up to date.
So perhaps what you're suggesting then is calendaring a review of plan documents, whatever that might be, your investment policy statement, maybe your plan document. Not that you necessarily need to go through a complete compliance review, but just sort of taking steps to make sure that you are following what you said you're going to be doing.
I think that's a great idea, and I also think it's a good idea just just as a matter of general prudence. For example, if you have an investment policy statement, for example, to make sure that your committee members have that at every meeting, and make sure they have like a little notebook perhaps of key documents, their committee charter, their investment policy statements. Just a sort of a set review is a great idea, but also just having that in front of people so they remember, hey, these are the documents that govern us, and these are the documents we have to follow. And if we're not doing it, there's nothing wrong with that necessarily, but we're going to have to explain why and explain what we did and why that made sense.
Okay, now we're coming up to one of the reasons, the reasons that we care about a breach of fiduciary duties. And that is mainly because if you are a fiduciary, you could be personally liable to the plan and beneficiaries. You could be required to restore losses caused by the breach. You could be required to disgorge any profits that were made from a breach transaction. So obviously, personal liability is a big stick. But it can also be that fiduciaries are subject to civil and criminal penalties and excise taxes. For example, the DOL can impose civil penalties. You could even be convicted of a crime and fined up to $100,000 or $500,000 if you're an entity, and you could be imprisoned, yikes, for 10 years or both. And I've actually had situations where I've wondered how far the Department of Labor will go before they will actually take steps. I was at a DOL investigation of a client of mine, just a random, I don't know if it was random, but it was just a routine investigation of one of their retirement plans, and the agent was telling me about a different entity, not my client, who she says she has a vest that says, is bright orange and says Department of Labor, and they go in and actually can confiscate plan documents and plan files and things like that. And I'm like, wow, that is pretty amazing. And that was because the plan sponsor was embezzling money from the plan. It actually really does happen. And it surprises me, but I have heard about it more than once now. So don't embezzle money from your plan. Probably don't need to say that. And then if you engage in a prohibited transaction, you'll be subject to liability for excise taxes. One of the biggest prohibited transactions that can occur, and I think people don't even realize it, is late contribution of 401k plan monies to the plan. Because what the Department of Labor would say is, as the employer, the administrator, you are supposed to be putting that money in as soon as possible after it's been segregated from the employer's general assets. And to the extent that you're holding on to that money and not depositing it into the plan's trust, you have use of that money. And so the interest or the earnings that you make on that can be considered, that's a prohibited transaction, and you should pay an excise tax on that amount of lost earnings.
So, and just to follow up on that, I mean, again, this is sort of the scary slide where you find out all the bad things that can happen to you, and there's the damages are real, and there is a very aggressive. One of the things that's happened in the last 10 years is we've seen the plaintiffs bar, who are very good at kind of smelling out new opportunities to become very aggressive in the ERISA space. A lot of securities lawyers started to figure out that ERISA is in a lot of ways easier to sue under than securities laws, and so we've seen some very aggressive plaintiffs lawyers come up with some very creative some creative ideas about how to make money and how to sue people. There's websites. I think it's still up, www.erisafraud.com, where the plaintiffs' lawyers will announce not only the people they're suing, but they will troll for, hey, do you work for a company XYZ? If you do, call us because we think there's problems with your plans. I've seen Facebook ads where people say, do you work for company XYZ? Call us because we think you're getting ripped off by your company. It's a very much a cottage industry of specialists who are looking for lawsuits to file. And just to follow up on one of Liz's points here, the one area where the DOL, and one area you need to be very, very careful about, is if you find your company in financial distress, and this is something the DOL will take extremely seriously. If you find your company in financial distress and money is tight and you're trying to find out how to pay bills, it's a bit of a minefield in ERISA because, just to give you one example, the payment of your health insurance premiums. A lot of that is funded by employee money taken out of their paycheck. And I see a lot of people there's a lot of lawsuits, and we represented a guy at trial who, was the company was going down, was struggling, and he was trying to marshal bills, figure out which bill he could pay. He didn't pay the health insurance benefit, and according to the DOL, he basically was a privileged transaction because he took employee money. And the DOL, because he should, the employee's money should have gone to pay it. And from this guy's point of view, at least that's the DOL story. Let's put it that way. But from many of the point of view of people who are in these situations, look, I'm trying to keep the company afloat. I'm trying to save everybody's jobs here. I don't want people to get out of work. But that's not the way the DOL looks at it. They will take very seriously commingling of employee money and the failure to remit payments and money due, particularly which is a big risk in situations where a company is sometimes in trouble.
I've come across that more times than I would have expected in a mergers and acquisitions setting. I'll have a client that is acquiring another entity, and they will merge the 401k plan into their own 401k plan after the closing. And I've actually had this situation where, and I was not involved in the due diligence. So think about this. If you're ever in a deal setting, make sure that they have actually been contributing money to the plan, especially in sort of a financial insecurity kind of situation. That's happened, and it does happen more than you would think. So that's a tip to worry about if you're doing deals. Okay, well, I think we've talked a lot about some of these already, but Andy, do you want to start talking
Sure.
about just sort of the general best practices?
And I think, again, we've covered most of these issues already. I think that, but these are definite themes that we want to kind of impress on everyone, is that remember that the exercise of fiduciary duty is about process. And you should be very comfortable not only documenting things and deliberating things, but also confronting difficult issues and documenting those difficult issues and what you did about them. Again, it is firmly my opinion that courts will want to be able to see good fiduciary process. And I think, frankly, that judges really appreciate when they see fiduciaries struggling with difficult issues, as opposed to not paying attention to them. I think that judges understand you were in a difficult place, and you were trying to make the best of a bunch of bad options, and therefore I'm going to give you deference, and I'm going to review your decision, to make sure it's only if it's reasonable, and that's what they're supposed to do. And I think that's what they do. What judges don't want to see, what will make them angry, what will make them question, is if people ignore things. So as a general rule, just as a general principle, document, deliberate, and don't hide from bad issues. And it's just somewhat of a counterintuitive thing, particularly for lawyers, where we're always trying to make sure that everything's perfect and there are no problems. But this is a different world, and you have to sometimes think about things in a counterintuitive way. Just one thing about privilege. And this is a sort of a universal thing that we always have to be careful about. And so you probably heard this before, but it's an easy thing to forget. And that's that in a fiduciary setting, attorney-client privilege works differently than you probably used to. For those of you who are lawyers, and for those of you who deal with lawyers, you're used to the idea that whatever communications you have with your lawyers are going to be protected and are going to be not disclosed in discovery. So you can have candid conversations. Well, that's not entirely true in the context when you're an attorney giving advice advice to a fiduciary. The idea is that there's this thing called the fiduciary exception to the attorney-client privilege, which basically says that if I'm a participant in a plan and an attorney gives advice to a fiduciary about their fiduciary duties, I get to look at that privilege. I get to look at that communication, because essentially that was, excuse me, that was delivered for my benefit. Now, we could spend an entire hour about all the ins and outs and nuances of what that looks like, and I'm sure none of you want to hear that. But the idea is that you just want to be very intentional about communications to and from a lawyer when you have fiduciary, when you're exercising your fiduciary duties. That doesn't mean that you don't want to get legal advice. As we talked about, prudence is all about process, and there can be times when legal advice is not only helpful, but it's something you want to absolutely have that advice in your file. There's plenty of times when we've been aware that litigation was coming, when we've drafted memoranda for a fiduciary, knowing full well that it was very, very likely going to be discovered in the litigation. And we thought, not only is this going to help the fiduciary do a good job, just not worry about litigation, but just fulfill their duties, but if it actually does get to litigation, it's going to be something very helpful for us, because it's going to show how they were diligent and taking advice and paying attention to things. And I'm couching a lot of these comments in terms of how to avoid litigation and to defend litigation. But the nice thing about all of this is that the same things that will help you be a good fiduciary and fulfill your duties under ERISA, sort of in the abstract, are the things that are going to help you in litigation. The last point we'll make here is just to reiterate: keep your documentation up to speed. Make sure you're doing what you're saying and you're saying what you're doing. And if you follow those principles, you will be in good shape.
So a question on the privilege issues that you were just talking about, and maybe I missed this, but I think that there is a point, though, where you do have attorney-client privilege. And isn't that when there is actually a conflict or some sort of issue that arises that makes the plan actually adverse to a participant?
Right, and so the limit to there's all sorts of exceptions and nuances, but that's a good point. If you are receiving attorney-client communication in your capacity as a sponsor of a plan, not as a fiduciary, but as a sponsor of a plan, that's definitely protected. If you are in litigation, so the way to think about it is: are you receiving this advice for your own interests? Or your corporate interests, or are you receiving this advice to help you fulfill your fiduciary duties? If you are a fiduciary and there is a claim for benefits and you are being sued, you can get attorney-client advice because you were receiving it for your own defense, to help you prepare your own defense. If you are deciding a claim for benefits and a lawyer gives you advice about how to decide that claim for benefits, that's a fiduciary function, and there's a reasonable chance, I'm not certain, but a chance that information will be discoverable. So, so if you are receiving it, and I think so the catchstone here, again, we could talk about it for an hour, but the catchstone is, or the key, I guess, is: are you receiving it for your own personal benefit, or are you receiving it because you are a fiduciary and you are exercising a duty on behalf of participants? So I don't mean to suggest that anything you receive in your ERISA capacity is somehow discoverable, but it's tricky, and it's very difficult, because sometimes the line between I'm trying to get advice so I don't get sued and I'm trying to get advice to fulfill my fiduciary duties, that's a hard line to walk sometimes. And so the reality is that everything we do to do a good job also helps us to prevent to get sued. And so again, it's very tricky, and you just need to be intentional about it, and you just need to be aware of it, and you need to make sure that you and your lawyer are thinking about it. I mean, we spend a lot of time thinking about, is this communication going to be a fiduciary, subject to the fiduciary exception or not? And if it is, what does that mean? At the same time, you can't hide stuff. If you gave them advice, you can't let this hamstring your ability, if you're a lawyer, to provide advice to clients, or if you're a client, to get advice from lawyers. So you just have to be intentional and know you're walking a bit through a minefield.
And just a plug for our next session, there is going to be a litigation update. These things actually do happen. There is litigation. And so stay tuned for the next session.
Thank goodness.
Thank
goodness. Where would we be without litigation?
I adore Andy, but I don't ever really want to have to work with him. But I'm glad that he's here when issues do pop up. So plan governance, excuse me, I think really, perhaps what we should talk about here are sort of your committees. If you have an administrative committee, how you should maybe think about structuring them, or do you want one, do you want two, do you want an administrative committee, do you want an investment committee? What should the size of that committee be? Who should be on the committee? And there's not an answer for everybody. I think that what you need to do is sort of look at your company, at the size of your plan, the complexity of your plan, and figure out what makes the most sense for you. Do you really want the board of directors or the CFO involved? If you're making some very important decisions and it relies on information that the board of directors or the CFO might know by virtue of those positions that they hold in the company, it becomes a tricky tightrope for those types of persons to walk, because they have information that might be confidential information about the company, but yet they're supposed to be acting in the best interest of plan participants. So sometimes it's a good idea to shield those persons from an administrative or an investment committee. It seems counterintuitive, but it actually does seem to make sense in many cases. And if you do have more than one committee, how are you sort of coordinating, and how do you know who has what duties? That's why having a charter and an administrative committee charter or an investment committee charter really helps kind of hone what each entity is supposed to be doing, how they interact, how they talk to each other, how do they talk to the board of directors. How often do you meet? Sometimes people meet 4 times a year. Sometimes you meet more frequently than that because you have issues that come up. Again, not one answer for those questions, but something to think about. And I think, having an educational session for your fiduciaries is really key, because that helps, I think, not only inform them about what their ERISA fiduciary duties are, but also you have then in place, as Andy would say, a document. Hey, we take ERISA and your fiduciary duty is important. We train once a year on what the fiduciary duties are, especially if you have new committee members join. This is not this is sort of an esoteric area. And, you put somebody new in on a committee, it's good for them to have a basis for understanding. They should want to know this too, by virtue of the fact that they could be personally liable for breaches.
So then the helpful thing about ERISA in some ways is that there's a tremendous amount of flexibility about how you structure your governance, which is nice in the sense that you have flexibility, which is nice, but at the same time it creates a bit of a danger in the sense that it's very, very easy for mistakes to happen or for unintended consequences of what you're trying to do. And the first thing I think you need to think about is making sure that you've divided if whatever you decide to do with that you're intentional about it, first of all, and ask yourself, there's this kind of struggle between, do we want the CFO, the CEO, the board of directors involved, which is helpful in the sense that they're usually your most competent people, and you want competent people to be handling this stuff. And not only that, but the CFO and the CEO and the board of directors are going to be concerned about benefits issues, and they want to probably have their finger on the pulse at least at some level. The downside is, of course, is that if there's a lawsuit, then suddenly your board of directors is going to be named, and the plaintiff's lawyers will always name the board of directors if they can, if for no other reason than just to kind of put pressure on you to settle. And do you really want your outside board directors to be involved in this? Is that a communication? Is that a conversation you want to have if a lawsuit happens? So you have to find your own balance there. It's particularly difficult if you have employer stock in your plan. Just because your CFO, CEO, board of directors are the ones that have the most inside information about your company's status, and if there's a problem, and the stock is going to go down, what do they do about it? How do they trade on inside information, which they can't do? At the same time, how are they going to manage this problem? So that's if you're an ESOP, that's a particularly fraught area, and I'm not going to go through all the. We could again have a day-long conversation about how to deal with employer stock issues, but you just have to ask yourself, is that something you want to do? If you do, go for it, but just be intentional about it. it also that also kind of raises the point about what I said before about document drift or about drift, right? Let's say you decide I want to insulate my board of directors. I've seen situations, for example, where somebody wants to insulate their board of directors from all potential problems and all potential risks. But then all of a sudden what happens is the board is getting an update every year on benefits matters and the costs, and suddenly they start getting information about the investments and how is the plan performing, and then suddenly they're the ones appointing people to be on the committee. Well, on the committee that reviews things, or maybe they're looking over their shoulders. Well, suddenly, the board has put themselves in the fiduciary lineup by becoming a functional fiduciary, by taking action to protect the plan. There's nothing wrong with that, but again, if that's not your intention, you need to be careful about it. I mean, I think there's a great thing to have the board look it over. It's a great part of process to say, we're so concerned about benefits that our board looks over it. That's a great story if that's what you want to do. It's not necessary to do it, though, and you just need to make sure that if that's what you intend to do, that you do it, and if you don't intend that you don't do it. Again, I think that we all know that you have to have independent fiduciaries or investment advisors, and if you're managing a pension plan, unless you're an investment company yourself, you're involved in the investment world, the practical reality is you're not going to be. It's going to be a challenge, let's just say, to manage your own investments on your own. But I think it's very critical to make sure that you're kicking the tires on what your investment experts are doing and who they are and what motivations they have. How are they getting paid? One of the big sort of as you may know, there's been a whole series of lawsuits brought by plaintiffs' firms against 401k plans. And one of the big sort of outcomes of that is that to recognize that oftentimes investment advisors, not always, but oftentimes, the way they get paid can give them perverse incentives to recommend certain things. And I think in the vast majority of situations, of course, people manage that, but in some situations they don't. In some situations, your investment advisor may be being paid by record-keeping fees or by 12B1 fees. And in that instance, they may have do they have an incentive to recommend a higher, a more expensive fund? Are they making money off it? It's important that you understand how your investment advisors are getting paid. Particularly in bundled relationships where you have if somebody provides investment services or mutual fund services, but also record-keeping services. How are they getting paid? Are those fees reasonable? And is there any reason to be concerned about the incentives that your advisor has? Again, not to say that that's necessarily a problem, but you should know about it, and you should make sure to kick the tires on that and make sure that the advice you're getting doesn't raise any concerns in that area. The only thing I'll say about committee meetings and things like this, I mean, certainly it seems standard to have meetings that are quarterly. That certainly seems to be sort of the standard. I think with the understanding that if issues come up, that you'll have sort of informal meetings. If you have those sorts of informal meetings with emails going around, I mean, oftentimes that's what committees do. An issue comes up, you send those emails around. Make sure those are saved. Make sure that there's some process that if there's an assistant who's responsible for it, somebody who's responsible for keeping those records, because that can be very helpful. The DOL, for what it's worth, just a little bit of advice. DOL has a surprisingly overbroad view of how often people are meeting. I know that they've talked to clients saying, well, for this plan you should be meeting every month for a whole day, which seems excessive. But just make sure that you're giving enough time to your meetings, and that you're not that any of you wouldn't, but that you just realize that attendance at the meetings, the length of the meetings, that's something that plaintiffs' lawyers would look at, or the DOL would look at in determining your fiduciary process.
Okay. Settler and sponsor functions. This, again, sort of is the two-hat question. Who's amending the plan? The amendment itself is a plan sponsor function, but then once the plan is amended, who's administering it? And then it switches over to a fiduciary administrative function. And then sort of assigning and dividing settler and fiduciary functions, that goes back to, I think, oftentimes the charters that we were talking about, where it sets forth very clearly who's responsible for what.
Yeah, the only point I'll raise here is just the point I've been making about be careful about assigning duties to who, and making sure that those aren't hidden fiduciary duties, and make sure that your plan is flexible enough so that if you and this is something that actually comes up often, is like if you need to make an amendment to the plan, Sometimes people will reserve it for the board of directors. Only the board can amend the plan. Well, suddenly you have to make a relatively minor amendment to the plan, or something that's even major, but you need to make it quickly, and it's complicated to get the board involved. Is that something you want to do? Is there a way that you can have some amendments made by others, by individuals other than the board, just because of the complexity and difficulty of getting the board to make certain decisions? And you just have to think about that.
So, for example, something that doesn't cause an increase in benefits,
Right.
or an increase of benefits over X number of dollars,
Right.
perhaps something like that.
Yep. Or even just have dual entities that have the power to do it, with the understanding that, as a practical matter, the board will usually do it, but if there's an emergency, somebody else can. I mean, just think about the fact that, do you really want the board to be the only one that can amend your plan?
Okay, service providers. I think Andy has talked a little bit about this already, and we can go into more detail, but I did think it was kind of interesting. If you go on the Department of Labor website, they've actually, and I just have noticed it recently, really sort of bulked up the information that is out there by the Department of Labor about what ERISA fiduciary duties are and how you can fulfill them. And they actually have a section, I'll switch back to the next slide too. What does the DOL say to consider when you're selecting a service provider? And then what does it say to consider when you're monitoring a service provider? I'm not going to go into a ton of detail about those things, but just to sort of think about, the DOL actually is thinking very hard about these things and maybe has some guidance for you that is helpful. You were talking about fees. I know that when we talk about investment management and those types of things, it comes up there too. So did you want to talk a little bit about RFPs and benchmarking studies and things?
Yes, and again, the kind of going to the question that was asked earlier, the process for monitoring service providers, really, at least in theory, the abstract process isn't different than the process you would use for monitoring investments, for deciding a claim for benefits. The selection of service providers in many instances, or at least arguably, is a fiduciary function, and one of the sort of the revolutions that come with the 401k fee process is to recognize that people need to kick the tires on their service providers, understand how they are paid. I think the practices are much better today, but certainly once upon a time, and people, many 401k plans had no idea how their investment advisors were being paid. They just know they were free services. Well, maybe that's great, but at the same time, there's nothing for free, and they're getting paid from somewhere. And what did that look like? And there's lots of lawsuits where, an investment advisor was basically getting paid above market rates because they were getting, all the plans 12B1 fees. Again, practices have moved on, but it's important to understand how your advisors are getting paid. Are you having, there's any number of services provided to participants, for example, investment management services or investment education services that will help them to pick their funds or to put together a portfolio, computer services, things like this. Well, again, those can all be very, very good, but we should make sure to understand what those services look like, but also the relationship those service providers have to, for example, the investment companies. Do they have a relationship to Fidelity or Vanguard or something that will cause them to make money off that relationship? And if so, is that something you need to think about when they're giving your participants advice? Obviously, service providers have an obligation to start disclosing where they make money and where they make their fees. Those should be studied and understood. And again, none of this is to say to be afraid of service providers or to say that these are issues that can't be overcome. They're just saying that that's something you need to deliberate about, to understand, and to make sure that you've kicked the tires on.
Okay, so when it comes to investment management, a couple of things that I wanted to mention. I had mentioned ERISA Section 404C and then QDIAs, Qualified Default Investment Alternative Options. And those are ways that you can sort of set up your investment lineup so that you will have reduced potential for liability for selecting improper investment options. ERISA 404C requires you to put out a variety of different kinds of funds with different risk characteristics, make sure that people can change their options on a frequent basis. I think for the most part, people have gotten 404C down. QDIAs, for example, a lot of people have target date funds. But again, those are funds, excuse me, that you want to have and select and think about sort of what makes sense for your participants. For example, some plans have brokerage accounts. Brokerage accounts can be great because it allows participants to select a worldwide of funds, a multitude of funds that would not normally be in a plan as sort of just the selected investment options by an investment committee. But is a brokerage fund really good for all of your participants? How are you going to inform participants that there are risks to investing in any kind of investment option out there? So you'll need to have communication, education. Maybe you want to limit the amount of your account balance that can be in a brokerage fund investment. Again, that is going to depend on your plan participants and population, their expertise. I have clients that are investment managers. They think they know more than anybody about investments. But then again, they also have assistants. And do those assistants actually know enough to be able to invest in a brokerage account? So those types of things to think about. Again, participant education. Fees, how to deal with third-party advisors, make sure that you know their fees, make sure you're selecting and monitoring them, and doing all the things that we've been talking about.
The brokerage window, why don't you go to the last one?
Okay, yeah.
The brokerage, we'll go to the last one. I think we want to leave a couple minutes for any other questions. But the brokerage window kind of provides a good example of what we're talking about here. I don't think anybody would say that in the abstract, the decision to offer a brokerage window in addition to a bunch of funds, a prudent lineup of funds is inherently a breach of fiduciary duty. But at the same time, it's not inherently. A plaintiff's lawyer could certainly put together a claim, at least, that there's problems with it because it's inevitably going to be more expensive, and you might have parallel funds there that are more expensive than your core funds. And the question is, a plaintiff's lawyer could easily say, this is a claim that you've seen from time to time that's kind of arising, that the brokerage window funds were too expensive and therefore they shouldn't have been in there in the plan at all because why bother? And if you have that meeting minute where you deliberate about it and say, yes, we realize that this is an issue, but we think it's a good idea because we like to give participants choice. That's a much better story to tell than just simply having a brokerage window there and having to explain to the court why choice is a good idea. You want to see that kind of deliberation and that thought. There's a lot of things that can be, that just kind of goes to what story you're trying to tell here, and why do you think this is a good idea for your participants? Deliberation with and reasoned decisions are always better to deal with, are always a very, very helpful thing. And I guess, most of what we're saying, most of what I've said here is just also in this last slide. I won't go over it. A couple other points just to make clear about, make sure that your indemnification language and your fiduciary policies are up to date, that you understand those, that you understand that your fiduciaries are protected in case of a lawsuit. We also make sure that when your service providers, when you're contracting with them, this is something I should have said before. One of the issues you see oftentimes is that your indemnification language is so broad that your fiduciaries, that your service providers are essentially have the right to receive indemnification from you for anything that goes wrong unless they commit fraud. Well, really? Is that what you want? If they make a mistake, or even if they don't make a mistake, if there's just an error if there's an error that happens, are you sure that you want them to come to you for full indemnification and returning an attorney's fees in any litigation? Maybe that's what you just have to accept. Maybe there's no other way to get the service. Maybe that's the contract they'll give you. But just be intentional about it, because indemnification issues are oftentimes broad indemnification language in service provider contracts is oftentimes something that is very. It's an issue that many people face. And the last thing I'll say is, one of the best ways to understand, the good fiduciary process is to understand the litigation trends that are out there. Once upon a time, nobody really thought about 401k fees as an issue, or at least, I shouldn't say nobody, but it certainly didn't seem like many people thought about it, I'm certain. But at the same time, there was many that just really didn't see it as an area of litigation or an area of threat. And all of a sudden, one day in 2006, somebody filed like 10 lawsuits all in one day saying, hey, you know what, fees are a big problem here. And all of a sudden everybody woke up and said, whoa, not only, I shouldn't say, again, not everybody, but many people who weren't necessarily paying attention to it woke up. And had you watched those trends, you would have seen the issues. Well, for example, one of the things we're seeing right now is cybersecurity and ERISA plans. And that's an issue that's kind of percolating among the plaintiffs' lawyers. And if you know that trend is out there, then you can start to think, hey, that's right. There's an argument that the data from our participants has to be protected as a fiduciary, at least. And what are we doing about that? Keep ahead of the trends. Understand what the plaintiffs' lawyers are looking at, because that's a good area, not only to find out where you're going to get sued, but to also understand sort of the things you need to worry about as good fiduciaries. Questions? Yes.
You comment on the indemnification policy versus the fiduciary insurance. So what do people do? Do they rely on internal indemnification policy, or they go out to purchase insurance?
I think that.
Question.
I'm sorry. Oh, sorry. Yeah. The question is, the question is, do people rely on indemnification provisions to protect their fiduciaries, or do they go out and purchase insurance? I don't have statistics about it, but I certainly, in my experience, the vast majority of people I'm working with do have fiduciary liability insurance. And I think it's important to recognize that most policies, most D&O policies will carve out ERISA fiduciary issues. So if you just have a standard D&O policy, there's a pretty good chance that it carves out ERISA fiduciary liability. And that's usually a separate policy or separate rider that you have to purchase. I'm not saying that's true for everybody, but oftentimes that is the case. So don't assume that just because you have a general D&O policy that's going to cover your fiduciaries. Obviously there's nothing that in ERISA that requires that your fiduciaries have an insurance policy, but it's very, very common is what I would say, and it's very, very helpful, because otherwise, your company is going to, if you're assuming you have an indemnification provision in your plan, your company is going to be paying for it. And if you don't have that, or if it's not broad enough, or if it's not carefully written, then everybody's going to be on their own. And your fiduciaries are going to be on their own, and they can be individually liable, which is not a situation I think that anybody wants to find themselves in.
Well, thank you very, very much for attending our session, and we look forward to seeing you in the next session.